starts with Adamson doubting his decision to sue Time Warner. We believe that his decision to sue has been one of the key mistakes that Adamson has made. US litigation is known to be time-consuming, expensive, uncertain, and invasive. First, a lawsuit is a lengthy process as many steps besides the actual trial are involved. To illustrate, ORC's lawsuit will take more than 2 years, thereby ending after the patent terminates. Furthermore, ORC's litigation process is estimated to cost over $2 million. Also, as the result of the trial taking up all of ORC's resources, ORC has decided to temporarily shelve the research program and reduce the technology department in size. Moreover, ORC's management spent a considerable time gathering records to use in court. And lastly, as the outcome of litigation is unpredictable, Adamson is betting the entire future of ORC on one court case. Now, instead of the litigation process, there are other forms of dispute resolution which ORC could have pursued. The 3 basic forms of alternative dispute resolution, ADR, are negotiation, mediation, and arbitration. A comprehensive overview of the advantages and disadvantages of dispute resolution methods is provided in the appendix. One of the main advantages of ADR is that it's less expensive than litigation, which could have prevented the cash flow issues that ORC was experiencing. Another advantage is that information is private. Therefore, ORC could have saved face with Asian clients when pursuing ADR. The litigation process is public, hence exposing ORC's issues to all its stakeholders, which can diminish ORC's appearance of stability and competence. Both arbitration and mediation use third neutral parties, which help to resolve issues. However, arbitration also offers the possibility to binding, allows for more procedural fairness, and permits third parties with expert knowledge to resolve the case. Thus, when using binding arbitration instead of litigation, the involved organizations could have chosen an arbitrator that has technical know-how of the patenting process and technological complexities to fairly rule on the case. The arbitration should be binding to ensure that both parties keep their promise and the patent does not expire before another party takes action. When arguing whether Sony, Philips or other manufacturers were allowed to refuse the licensing deal with ORC, the 4 conditions required for a valid patent should be examined first. The first condition for a patent is novelty. Since there was no invention or information available similar to Russell's newly developed technology before 1975, the digital optical audio recording satisfies novelty. The second and third conditions are that it's non-obvious and useful. Before Russell's invention, the gas ion lasers were bulky, expensive, and impractical. His patent invention was a significant improvement, as the diode laser was light, compact, and an affordable consumer product. Hence, the development was both ambiguous and had a practical use for the consumer, which provided a real-world benefit. The final component is that it's a patentable subject matter. Since the technology is incorporated into a physical CD player, it is not a scientific principle nor an abstract idea. Hence, Russell meets this final condition. Although the patent has been demonstrated to satisfy all the conditions, the validity of the patent was being challenged by the competitors. In fact, the Prior Art Act prevails as one of the core concepts in the case, which constitutes the basis of defenses claimed by Sony, Philips, and other manufacturers. Such developments have led Adamson contemplating whether any unanswered prior art references could render ORC's patent uncredible. However, as the case unfolds, it is observed that the Russell patents could overcome the invalidity challenges from the prior art. Equally substantial, it is emphasized that all CD products were subject to the compact disc technical standard, whose violation would result in infringement. Thus, the case explicitly states that the patent was valid, which is congruent with the analysis in the previous slide. Furthermore, prior art has a strategic implication given that all the counter-arguments against patent infringement revolve around the invalidity and non-infringement defenses.
The invalidity argument of the manufacturers revolves around the territorial scope enforced by the long-arm statutes, as well as the validity of ORC's patents. Since Sony is planning to export to the US and Europe based on the long-arm statutes, Sony could not refuse the licensing deal. Philips could question the validity of the patent due to the weak patent protection in the Netherlands. However, like Sony, Philips needs a licensing deal to export its products to areas with strong patent protection. Time Warner, DuPont, and EMI were not in the position to refuse the licensing deal with ORC, since ORC's patent has a very strong position in the American, Canadian, and British markets. Based on the Prior Art Act, the infringer's invalidity and non-infringement defenses were shown to be incompetent. Also, the manufacturer's intention to export the patented products to the US and Europe is prohibited according to the long-arm statutes. Therefore, the manufacturers were not in the position to refuse the licensing deal with ORC. There are some benefits to litigation. First, if ORC wins the case, it can be awarded up to $81 million due to the potential tripling of damages of $27 million. Moreover, only the court can give a verdict of injunction, thereby forcing Time Warner to stop producing patent-infringing products. In addition, as the case takes place in the United States, a positive outcome for ORC can create a beneficial precedent for future cases relating to the infringement by other US companies, such as DuPont. However, this can also backfire if the court rules in favor of Time Warner, and thereby create a detrimental precedent for ORC, which could inhibit it from winning future patent court cases. Furthermore, the greatest threat to Time Warner, that of an injunction, is diminished as the Russell patents are expected to expire before the court has ruled on the case. In addition, should the court case result in anything less than a complete endorsement of ORC's infringement claims, ORC's entire licensing program could collapse, including the quarterly payments from Sony. Another downside to litigation for ORC is that the ruling could be public, which can undermine ORC's reputation. This is especially important for their Japanese partners. Moreover, ORC is struggling under the financial strain of the litigation process. Adamson already had to scale down ORC's research department. This gives Time Warner an incentive to drag out the litigation process in hopes that ORC capitulates before a ruling can be made. Lastly, the fate of ORC depends on the verdict of the jury, which has been confused by the technologies and is overall unknowledgeable on the topic of patent law. Therefore, ORC should try to settle the case under binding arbitration, as an arbitrator that is well versed in the specific of the case makes the ultimate verdict. All in all, Adamson should try to settle the case instead of pursuing litigation. As mentioned in the first question, we believe that solving this issue outside of court would have been a preferable option all along.